Young Thug's attorney arrested, Hunter Biden guilty. It's time to break down these cases. Now, attorney Brian Steele was arrested and held in contempt of court during the middle of the trial for refusing to give up his source for an ex parte communication that was held between the judge, the state, and witness Kenneth Copeland. It is very unusual for an attorney to be held in contempt of court. It's not impossible, it just doesn't happen often. Last time I heard about an attorney being held in contempt of court, it was an attorney by the name of Fletcher Reed. And he was,
Bad baby, bad baby. Mr. Reed.
Unique. If you're doing stuff like that, you kind of deserve to get arrested. While in court, the judge is asking Attorney Steele to give up his source as to how he was informed of the ex parte communication. Attorney Steele doesn't want to give this information because he feels like he might be violating his ethical obligations to confidentiality. Judge Glanville disagreed. He thinks that if he gives a court order, it should absolutely supersede any type of ethical obligation that you have. Attorney Steele stands his ground and says, you know what? No, I'm not giving up my source. For me to give up my source, it would be doing a disservice to my client. I'm not saying anything.
Not snitching for doing what your mama told you to do.
The judge said, fine, get locked up. 10 weekends in jail. This is the longest case in Georgia's history, and it seems like they're determined to make it even longer. Now, Steele and his law firm filed an appeal stating that the judge holding Steele in contempt of court was incorrect. Judge Glanville's sentencing Attorney Steele outraged attorneys throughout Atlanta who actually came forth on behalf of Steele and argued that the sentence was unjustified. Now, attorney Ashley Merchant argues on Steele's behalf that he should be entitled to a hearing for a criminal contempt charge. What was Judge Glanville's response?
No, God!
I don't think so. But guess what? Attorney Merchant came prepared. She cited case law from 1994 showing that a criminal contempt charge requires a hearing. You know what the judge said to that? I don't like that case law. It's too old. The Constitution? That's pretty old, but it's there for a reason. Attorney Merchant's response as to why the case law is so old is basically the fact that this doesn't happen that often, so there's not a lot of case law to use. Attorney Steele requested that he serve his time in the Cobb County Jail, where his client, Young Thug, is also serving his time. I can't tell you when's the last time I've seen an attorney representing his client from the same jail cell. If anything, I think it also shows just how far Attorney Steele is willing to go to make sure that his client is properly represented, which, as a counselor myself, I love to see zealous advocacy, so I tip my hat to you, Attorney Steele. The silver lining to this case, the Georgia Supreme Court granted Attorney Steele an emergency bond, so he was able to spend Father's Day weekend with his family. Oh, Hunter, what are we gonna do with you, man? Hunter Biden, convicted on 3 felony gun charges for the purchase of a 2018 revolver while he was in the midst of a crack cocaine addiction. That is a real headline, not a joke. The prosecution proved that Hunter Biden violated laws that were created to prevent drug addicts from owning firearms. Truthfully, as the law goes, it makes sense. I don't really know that we want drug addicts having firearms. I don't even think non-drug addicts are doing so hot with firearms. As a result of the conviction, Hunter Biden now faces up to 25 years in prison and $750,000 in fines. He'll have to sit with the probation officer to gather more information so that way the probation officer can give a judge their pre-sentence report. Along with Biden's probation officer's pre-sentence report, both the prosecutors and Biden's defense attorneys will be submitting pre-sentence memos. The judge takes all of these documents into account before delivering the final sentencing. Sentencing usually happens within 120 days from the verdict. Now, even though Hunter's been convicted, what might be a saving grace in this situation are federal sentencing guidelines. Now, federal sentencing guidelines are standards that are used to ensure consistent and reasonable sentencing practices are being followed. Basically, they're there to ensure that no judicial authority is egregious in any type of sentencing that's being handed down. Given that Hunter Biden's record has been pretty clean and this is his first offense, more than likely he's not going to get the full 25. He's not going to have to pay the full $750. Truthfully, he may not even see any time behind bars. But only time will tell. Let's say the judge decides to sentence Biden to prison. What happens then? More than likely, sentencing will probably be delayed because Biden's attorneys are more than likely going to appeal any type of lengthy sentence that doesn't really make sense or doesn't really conform with federal sentencing guidelines based off Biden's lack of criminal history. Here's an important question. Can Hunter Biden still vote? And the answer to that question, in typical lawyer fashion, it depends. It depends on where Biden is registered to vote and what that jurisdiction's laws are with regards to allowing felons to vote. Now, some jurisdictions don't allow people convicted of felony crimes to vote, period. So, ultimately, it's going to come down to where's Hunter Biden registered to vote. What's unfortunate for Hunter with regards to all of this is the fact that President Biden has already said he will not provide a pardon to his son. If you're seeing a high-profile case in the media and you're having trouble understanding the reality of the legality behind that matter, first, remember to like, comment, and subscribe to the channel. And secondly, always remember,